to Washington Legal Foundation's media briefing. My name is Glenn Lammi. I am Executive Director and Vice President of Legal Studies for the Foundation. For those of you not familiar with the Foundation, we're in our 48th year of free enterprise advocacy and education that we practice in a number of different ways. We have a litigation division that files amicus briefs in federal and state courts, files regulatory comments as well, sometimes requests for rulemaking and occasional original litigation. Our legal studies division, which I run, is our think tank, for lack of a better term. We do publications, programs such as this one. We have a blog called the WLF Legal Pulse, and we get involved in a very wide range of issues that affect the free enterprise system, innovation, and the conduct of business in America. Our website's WLF.org. If you want to check it out, definitely would appreciate it. So the pair of cases our panel is discussing today took a remarkably rapid path to the Supreme Court. Most cases take years. Learning Resources and V.O.S. Selections filed their complaints in federal court this past April. That quick ascent, however, did not impact the quality of advocacy or the level of participation from interested parties. In addition to such frequent amicus filers as WLF, the U.S. Chamber of Commerce, and members of Congress, the docket includes amicus briefs from former U.S. Trade Representative Carla Hills, 31 former federal judges, the Game Manufacturers Association, and something called Princess Awesome, which someone at my age really doesn't know what that is, but that's great. Given the trillions of dollars at stake in this case, something you hear repeatedly by one of the parties in both of the cases, not to mention the separation of powers implications, one would expect such broad interest. Oral arguments are now less than a week away, November 5th, so we're here today to prepare you for what's ahead. Let me introduce our panelists, and then we'll get started. Peter Brann is a partner with Brann and Isaacson located in Lewiston, Maine. He's litigated corporate intellectual property and constitutional litigation cases before state and federal courts in over 20 states and before state and federal agencies. Peter is the former state solicitor for the state of Maine, responsible for all of the state's civil appeals. He's counsel of record on an amicus brief that Crutchfield filed in Learning Resources and V.O.S. Selections versus Trump. Professor Marc Busch is the Carl F. Landegger Professor of International Business Diplomacy at the Edmund A. Walsh School of Foreign Service at Georgetown University. Marc is an expert on international trade policy and law, having previously served for 2 terms as a cleared advisor on technical trade barriers to the U.S. Department of Commerce and the U.S. Trade Representative. He writes a bi-weekly opinion piece on international trade in The Hill, which I highly recommend. They're very good, and is one of a group of trade scholars in economics, politics, and law who filed a brief in the tariff cases we're discussing today. Finally, Zach Morgan joined Washington Legal Foundation in 2025 as Senior Litigation Counsel. Before arriving here at WLF, Zach served as counsel to Commissioner Alan Dickerson of the Federal Elections Commission. Zach also spent 8 years litigating First Amendment cases as a staff attorney for the Institute for Free Speech, and he is responsible for the 3 amicus briefs that we filed in Learning Resources, including our merits brief that we filed last week. Just want to remind you that we're recording this program. If you have any questions for our panelists, please use the Q&A function, which is located in the Zoom webinar toolbar at the bottom. And if you're actually watching this as a recording on YouTube, please like and subscribe so you can keep up with our work. So let's get started off by talking about the law that the Trump administration says grants it the authority to impose taxes. Marc, what does that law say, and why did Congress pass that law?
The irony is that Congress passed the law to rein in what it saw as some of the abuses of the non-war emergency powers delegation to the executive in and around the Nixon period, but in particular, Nixon's abuse of, in Congress's view, potentially speaking, 5B of the Trading with the Enemy Act, wherein the president decided to impose a 10% tariff for a short period to deal with major fluctuations in the valuation of the US dollar in 1971. So therein lies the first irony, which is that actually IEEPA, along with the National Emergencies Act, were intended to limit this kind of abuse. The administration started off before the Court of International Trade with a pretty broad interpretation of why IEEPA was permissible of tariffs. But the underlying logic was essentially that it had no guardrails. So if you're going to impose sweeping tariffs on everything from everyone, the last thing you want to do is get embroiled in some of the reporting and the guardrails that we see under, say, Section 301 or Section 232. The question, though, which has since been ruled upon twice and hopefully will go the same way a third time, is does regulate amount to a synonym for tax or tariff? The majority opinion at the Court of Appeals for the Federal Circuit said no, that would be really allowing way too much latitude. The dissent had a slightly different take on it, but seemed to want to draw on the foreign policy implications and give the president credit for his bargaining chip strategy with respect to using tariffs to drive some concessions from others. The real interesting question, though, is the economics of all this. So obviously, IEEPA is about unusual and extraordinary threats emanating from abroad, and you get licensed to deal with those through some kind of measure, which historically has meant freezing or sanctioning assets of foreigners. But none of that seems to really be at issue here, in as much as a persistent goods trade deficit hardly amounts to something that is unusual or extraordinary, and the deal with part won't be met because a tariff isn't really going to remedy a trade deficit of any stripe. So what the administration seemed to do as a bit of a Hail Mary throw was to argue that at the end of the day, IEEPA must have been aware of the Yoshida II verdict. The Yoshida II verdict, at today's equivalent of the Court of Appeals, said maybe regulate could permit some tariffs, but if they were to be done, they'd have to be like Nixon's, short-term, not in violation of constitutionally mandated tariff schedules, etc. And the majority of the Court of Appeals said therein lies the problem for the administration. They're cherry-picking Yoshida II. They're running with the first half while ignoring the second half, which obviously, given the size and scope of these tariffs, is a bit problematic. But more generally, the argument for saying no to these tariffs is the other statutes. And I know we'll get into Section 122, 301, 232, and the smorgasbord of numbers later on, but the real dark horse in all of this is Section 122. Because if you look to the original congressional intent to give Nixon some tool to deal with what happened in 1971 through 73, it was Section 122 on balance of payments. It was not some misunderstood way of getting around Section 122 under IEEPA. And that is a big deal going forward.
So a lot of the briefs talk about the impact of tariffs on the U.S. economy. The administration, on the other hand, says that curtailing the tariffs would be, quote, ruinous and catastrophic. Marc, can you talk a little bit about the economic impact on tariffs of this sort of breadth and magnitude on the U.S. economy?
We're seeing a big impact, obviously. No one would have expected otherwise. But there are two ways to understand how big an impact we're really witnessing. One is to focus on the rates, which are changing at the president's whim. And they're upending supply chains. They're curtailing a lot of enthusiasm for hiring and investing. The M&A business has been ground to a screeching halt as a result of the tariff uncertainty. And as we all know, the pass-through rate on these tariffs is upwards of 80%. The idea that somehow foreigners and foreign exporters in particular are eating all of this cost is preposterous. But the key is that uncertainty. And what I'd add to the mix of discussions being bandied about in the amicus briefs is that we know what this uncertainty does. It is tremendously harmful in terms of business planning. It's a massive tax on trade. So the rate is the first part of the story, but the uncertainty around that rate is the second. And when you watch what Trump did to Canada the other day in retaliation for an ad on a baseball game, raising the tariff by 10%, that should be Exhibit A next Wednesday in terms of the need to curtail this kind of abuse of authority, which was never delegated under IEEPA or any tariff statute for that matter. So just given what the WTO can credibly claim as one of its best advents, namely demanding these bound rates be respected by all members of the institution, you violate those rates, which ironically was part of the Yoshida II story, and now we're into the world of who knows what's going to happen. And that's the really scary part of this whole scenario, that yes, the rates from a baseline of 10 upwards to 50, those are distressing enough. But the fact that there's no constraint, no cap, no ceiling, That's really where the problem begins.
Peter, the brief that you drafted for Crutchfield does a great job of describing the impact that even threatened or delayed tariffs could have on a company. Can you talk about that a little bit, please?
Sure. Crutchfield, they sell electronics basically across the country on the internet. And they get almost all of their product not because they want to go overseas, but that's where you have to go to get it. And so they're really highly dependent on tariffs and also the different rates. But the way in which the rubber meets the road here is that if you can change them on a whim, uh, they could go up, they could go down, they could go sideways. You really you can't plan. So, for example, Crutchfield, they started out as selling stuff on catalogs. So those of us who are older remember what a catalog is. And when you do that, you have to come up with the prices. You have to figure out the long supply chains of getting the product across overseas. You have to figure out how much, where it is, how much you're going to, and more importantly, what you're going to charge for it. So you put the price of what your product is in a catalog, and guess what? You're stuck with it. And so it doesn't matter that, oh, well, we hear today we're going to reduce the tariff of Chinese goods by 10%. Well, that doesn't really help you if you ordered your product back in May or June. As we said in the brief, Irving Berlin wrote White Christmas in the middle of the summer. And that's about the time when retailers like Crutchfield have to make their decision as to are we going to go or no go on selling this product and how much we're going to sell it for.
One of the more eye-opening things that was in your brief, Peter, was that there's not only do consumers expect prices to be accurate, so do regulators. So, for instance, in California, you likely can be sued under the consumer protection laws if you tell consumers one thing on the catalog, but then have to change the price when you talk to a consumer or send an email or whatever, right?
Yeah, absolutely. I mean, I got my start back in the Attorney General's office, and we used to bring what were called bait and switch cases, where you come in, you think you're going to get the dryer for $220, and then you walk out and it was $320. People are unhappy with that, and state attorneys general and other folks can file suit, and they will.
So, Zach, before we get into the arguments for both sides, can you talk a little bit about the two different appeals court cases that were appealed, and the V.O.S. case and the loaning resources case? How are they similar and how are they different? You're still muted, Zach.
Sorry about that. First sin of trying to communicate online, always forgetting to turn off the mute. So as soon as the president started doing this, he withdrew a number of legal challenges. Most of those challenges got shuttled to the Court of International Trade, which handles cases that arise from tariffs. And two of those cases are V.O.S. selections, who came in along with Oregon and 11 other states challenging the tariffs. And one of the cases stayed in the U.S. District Court for the District of Columbia, and that was Learning Resources. The Learning Resources Court reached the merits because they concluded that IEEPA didn't allow for tariffs, so it couldn't be a case arising from tariffs. So there was no need to transfer it. By reaching the merits, they figured out their jurisdiction. And that case then was appealed immediately to the DC Circuit, but there was never a judgment from the DC Circuit. The court ended up taking cert before judgment because the Court of International Trade case was appealed to the Federal Circuit, which ruled 7-4 that IEEPA does not allow for the president's tariffs. And Marc's exactly right in what they said. They said it doesn't qualify for the types of tariffs that the president's been doing by executive order, but left open the possibility that IEEPA is a tariffing authority. So there was a division between DDC, which said, no way, no how, and the Federal Circuit, which said, well, maybe if you did something that looks like how Nixon handled the gold standard and the collapse of the international gold standard system in 1971, maybe you could do that. And so the court took cert.
So, Peter, once this gets up before the justices on Wednesday, what do you think? Which arguments do you think the Solicitor General Sauer is going to lean most heavily on before the justices?
My prediction is that they're gonna go hard on this is all just foreign affairs, and the president is the big kahuna in foreign affairs, and you can forget about all the rest. The rest of that stuff's not that important. They definitely are signaling that that's where they're going, that they think that that's the path to victory. The courts have shown really quite a bit of deference to the president whenever you can invoke the word foreign affairs. Doesn't matter that the tariffs actually are specified and identified in the Constitution as something that Congress is supposed to do. It's more, well, this is just a foreign affairs issue, and I think they'll have definitely some people who are open to that. Justice Kavanaugh is very big on the foreign affairs angle. Uh, Years ago, Justice William Brennan said that the most important skill in the Supreme Court is to count to five. And so when you count to five, you start to say who you're going to get. And I think that's the easiest way for them to do it.
Do you think that that's what they're going to lean on to
Yep.
get a broader interpretation of IEPA in terms like regulate and
Well,
importation?
it's just they're going to say because it's foreign affairs, yeah, Mark, you have some great points and all of that, but yeah, the president has a different view of what the emergency is, and that's the only view that counts. So that takes care of is it an emergency, even though the trade deficits have existed long before any of us were born, and likewise the ability to make decisions. Once again, the president gets to call those shots, and so then you're sort of detached from the language of the statute altogether if you just turn it into a foreign affairs issue. And then all those pesky issues of, well, does regulate really mean tariff, et cetera? Those flow by the wayside. And so I think that's the way in which the path they're going to take.
Thanks, Peter. So let's assume, Zach, for a minute that there are justices that want to focus on the regulated importation issue, and Solicitor General Sauer is going to have to address that. What's the counter argument to the government's claim that you put those two words together, IEPA authorizes tariffs?
I mean, I want to say that the best argument against it is just having a mildly sophisticated understanding of the English language, but that's probably a little too cute. So the IEPA has this 76-word provision. It's housed at 50 USC 1702 alpha 1 beta. And in those 76 words, there are two words. The president's right about that. There's regulate and there's importation. But they're not paired to one another, as the president's brief suggests they are. They're separated by 16 additional words, which use terms about compellence and voidance, the type of language that you would expect to find in a sanctioning authority, which is what IEPA really is. It's not a taxing or tariffing authority. It doesn't use the words tariff, duty, impost as all the other tariffing authorities do, which are housed, by the way, in Title 19 of the code, which is very nicely titled customs duties, whereas Title 50 is war and national defense. So you would expect the economic warfare provision to be in war and national defense, which is what it is. And but the president sharpshoots those two words and then gives them an uncommon meaning. I'm old enough to remember NFIB versus Sebelius. The power to regulate commerce is not traditionally understood as the power to tax. And yet that's what the president has to do. He has to say that regulate importation is the functional equivalent of the term tax imports. And this is why I think, I agree with Peter, the Solicitor General is going to lean hard on foreign affairs as a means for why you don't need to do the nitty gritty of statutory interpretation. But that's why I think this is ultimately going to get decided as a major questions case, because the president is imposing such an uncommon reading of the word regulate, isolating it from this very, very broad statute, and then using it in order to essentially claim control over the $7 trillion import-export market that the United States engages in, which, if anything, is a staggering economic claim, to borrow some of the language from some of the earlier major questions cases. I would contend that the president's claim that he now controls Article 1 tariff powers to be such a thing.
Marc, you referenced Section 122 earlier. That's something that the brief that you joined, the Trade Scholars brief, discusses at length. So what type of authority does that break the president, and why didn't the president rely upon that instead of IEPA?
He didn't rely on it because he doesn't like the guardrails, namely that the tariff is capped at 15% for 150 days. and that he would have to go back to the congressional well to get a renewal, which could be problematic, as we're seeing right now with respect to the votes in the Senate on both Brazil and Canada. I want to go back to the point that foreign affairs will change everything. I disagree. The reality is that both sanctioning and freezing have come up against the foreign affairs angle in the past, and they have been vetted accordingly. I don't see that foreign affairs is going to be a clear ticket in the event of tariffs. And let me put this boldly. Even if IEEPA allows for tariffs in the most stretched, bizarre way, you've still got Section 122, which precedes IEEPA. So the irony at the moment is that the DOJ admits they overlap. They are overlapping, and the president gets to choose, is the most state-of-the-art argument from the DOJ. And that is simply wrong. The choice is not the president's, because they don't overlap in a way that wouldn't nullify Section 122 if the president used IEEPA, even if it allowed for tariffs in the first place. So we have a big major questions doctrine problem here, in as much as you would essentially be giving IEEPA the ability to nullify every other tariff statute that had come along with the 62 Expansion Act and the 74 Trade Act, and that is a bridge too far. So I'm not terribly jazzed about this foreign affairs angle. I appreciate it, and everyone in their briefs has been gearing up for it. But at the end of the day, 122 is what Congress gave Nixon to deal with in a limited way anything that remotely ever looked like 71 through 73. And by virtue of the fact that for the United States, empirically speaking, and this is an important point that is getting raised in the case already, the balance of payments and the goods trade deficit are the same side of the same coin, empirically speaking. So when the dissent at the Court of Appeals tried to draw a distinction between something that it made out of thin air called the fundamental balance of payments problem and a persistent goods deficit, it just doesn't exist. So when you map the two onto each other, more so in 71 than today, mind you, never mind whether it's right to drop services trade from the calculation. They're walking in lockstep, empirically speaking. And that means that you should take seriously Congress's delegation for the sake of a balance of payments concern and not IEEPA. Moreover, at the time, it was clear that Congress meant by balance of payments that to be a synonym for trade deficit. So all told, there is the right tool, and black letter law says you use the specific before you go to the general. I'm really hopeful that the Supremes will see it this way, in as much as they've done it before. Despite foreign affairs, they can do it again.
So you'll see this as possibly coming up in the context of a major questions doctrine type argument.
Yeah, absolutely, and it should, because the ramifications of it not being addressed this way will be far-reaching and long-term.
So as Marc notes, Zach, there's limits in Section 122, and that's why the president didn't want to use that. In response to Learning Resources and V.O.S.'s arguments that IEEPA tariffs are limitless, the government in its brief points to the limits that IEEPA poses. What's the response to that point?
First, preach, Marc. That's absolutely, I completely agree with all of that. So yes, the president has sort of confected some limits that IEEPA has. The first thing that he notes is that, well, I have to declare an emergency. And so the National Emergencies Act of 1976 gives me the capacity to declare an emergency, and that's what unlocks IEEPA powers. If I don't do that, I don't have access to the suite of IEEPA authorities. The problem is that that's a very easy hurdle to get over. The president can simply declare the emergency. Also, speaking of bait and switch, the president contends that the president's ability to declare an emergency is not, this is the language from the brief, quote, amenable to judicial review. So the courts can't look at it. That's a core foreign policy power of the president. The other problem, of course, is the president also notes, well, the emergency declarations only last for 1 year. That's true so far as it goes, but they can be renewed endlessly. We are all of us still living under the 1979 emergency that was declared by President Carter in relation to the Iranian hostage crisis. That all of our economic sanctions against Iran, more or less, fall back to that emergency declaration, which unlocked asset freezing powers in IEPA, which are constitutional. The other thing the president notes is that, well, Congress can cancel the emergency. I believe it was Marc alluded that Senator Paul has forced some votes on the president's emergencies related to the Brazil and China tariffs. The problem, of course, is that in 1976, the joint resolution provision of the National Emergencies Act was a legislative veto. So that was a real check against the president. If both houses of Congress disagreed, they could cancel the emergency. No longer. 1983, Supreme Court decides INS versus Chadha. The Chadha court says the legislative veto is unconstitutional. That falls by the wayside. So all the limits on the president's IEPA authority all actually require the president to acquiesce in deciding that he no longer can tariff. So they're limits in name only. While the president has gamely offered limiting principles, I would humbly suggest that they are not limits in any real sense or understanding of that term.
Peter, you've mentioned this, so has Marc and Zach has as well, major questions doctrine issue. Can you put a little bit more flesh on those bones and talk about how that argument might be successful for the parties here?
Yeah, and to be clear, I mean, I drank the Kool-Aid long before I wrote the brief, so I'm not disagreeing with our esteemed colleagues here. The major questions doctrine, which was, of course, made up not very many years ago, and has been applied rather vigorously, and certainly was to the Biden folks, which says basically if you have an area which has really significant impact on the economy or politics, for that matter, of the United States, then we're really going to require it to be pretty clear that the authority is there. The sort of the great line from Scalia back in the day was, Congress doesn't bury, elephants in mouse holes. So you basically have to be pretty clear. And there's one thing that the opponents and proponents of these tariffs agree on, which is that there are literally trillions of dollars at stake, which actually exceeds all of the amounts that were used under this court to invalidate a number of the Biden COVID actions, student loans, evictions, and so forth, where they were talking in terms of mere millions and billions of dollars. And so there's no doubt that it satisfies that threshold. The way in which the administration tries to sidestep that, and which is what you saw in the dissent in the Court of Appeals, is, well, yeah, that's all well and good for domestic programs, but we're not going to apply that once we step out into the oceans offshore. And so that's the way in which they try and get around it. But I think it's fairly powerful. For me, anyways, I think it's more powerful when you combine it with the non-delegation doctrine, because you have an express authority given to, in this case, Congress, to basically raise revenue, set tariffs and duties and what have you. And so I think that actually provides a further limiting principle, which is they really, really have to be clear in light of this, the separate doctrine, which is, I think the two of them together go hand in hand pretty well, and would argue that, the Congress has to be clearer. And as a couple of folks have already mentioned, a statute where your two favorite words are separated by 16 other words that have nothing to do with taxing or tariffs or anything else like that is not exactly a clear roadmap.
So I'll ask this to Zach and then to Marc as well. The administration argues that the major questions doctrine doesn't apply here because, among other reasons, tariffs implicate foreign affairs. Does that hold any water, Zach?
Justice Kavanaugh, in his concurrence in FCC versus Consumers Research, sort of requested a lot of legal advice, and he got that from all the parties and all the amici here. He posited the major questions canon might not apply where a core Article 2 authority is at stake. And as a result of him writing this, everybody sort of interpreted that as, oh, he's signaling something about how he's thinking about the tariff case. So everybody felt a need to respond to it, including us. Our answer was pretty straightforward. That maybe that's true, but this isn't a core Article 2 authority. There's no independent constitutional authority to tariff. The right to impose taxes, duties, imposts, and excises is an Article 1, Section 8 power housed in the Congress. We're not talking about the sole organ doctrine or the president's commander-in-chief powers aren't at issue, so you don't need to assume that the statute was not intended to fetter the president, which we generally do in other national security contexts. Because again, IEPA is a national security statute, and sure, the president probably gets a lot of deference when he does an asset freeze or an embargo or imposes a quota or does the economic warfare that the statute rightly anticipates, but not tariffs. I mean, I don't think it's a coincidence that for 50 years, IEPA has been on the books, and not a single president has ever picked it up for tariffing authority. And I don't think that's because presidents Carter, Reagan, Bush, Clinton, Bush, Obama, and Joe Biden were shrinking violets when it came to executive power. I think that's because nobody, to do a little bit of deference to Scalia and quote him as Peter did, nobody thought that there was this elephantine tariff authority in this mouse hole of a word regulate. So no, I don't find that very convincing. I would be surprised to see a majority of the court fall down that road, but I do think Peter is right from earlier in the conversation that to the extent that the court is going to affirm, it's going to be on this bifurcation of the major questions canon and separating out the foreign powers from it. The other option would be to simply say the major questions canon doesn't apply to the president at all. It only applies to administrative agencies, which the president's brief does suggest. I don't see how that holds water because I'm a unitary executive person. The administrative agencies are part of the executive branch, so is the president. The canons of statutory construction fall on the president and the heads of departments equally. And I'd be very surprised if they took that approach as opposed to dividing the major questions canon in a foreign affairs domestic direction.
Marc, any thoughts on that?
Yeah, I'd like to see the argument put forward in the Democratic states amicus brief pushed a little further. How are these tariffs about foreign policy? What are we talking about? They're no more about foreign policy than the big, beautiful bill. They're a tax on American businesses and American consumers. Only by virtue of playing into this mythology of using tariffs as a bargaining chip did the dissent of the Court of Appeals endogenize foreign policy into this story. How are these about foreign policy? Now, am I going out on a limb pushing this one? You're damn right. But let's be real. I mean, is the big, beautiful bill foreign policy? It does exactly the same taxation. Why is the tariff, which is administered for the sake of raising tariffs at home, raising revenue, any more about foreign policy than that? The second thing I'd note is those online should definitely download the amicus brief submitted by Carla Hills and Alan Wolf. Alan Wolf is the guy who signed Nixon's order in 1971. And he goes out of his way to point out, we never said TWIA. We said the 1962 Expansion Act with respect to trade agreements. So if you go by that story, and there's a little bit of ex post fudging by the court to try and bring TWIA into it, but if you go by Alan Wolf's declaration, even the basis of cherry-picking Yoshida is in doubt. So all said and done, I've just learned a ton from some of these amicus briefs, and I gotta say, I just love this argument, which isn't fully pushed out, that tariffs are no more about foreign policy than domestic taxation schemes. Cut or raise tariffs, foreign governments aren't in on that action, and we've all foo-fooed the notion that we need an external revenue agency. Why are we playing into this idea that because the president says they're about reciprocals, which they're not, then suddenly this is of monumental foreign policy consequence? It's a tax grab. That's all it is. And we should be treating it accordingly.
Thanks, Marc. So, Zach, which justices should people who tune into the oral argument on Wednesday be paying attention to when it comes to the major questions aspects of this case?
Well, Justice Kavanaugh, for the reasons that I gave before, I'm very, very curious to what he has to say about whether or not he buys Marc's reading of this and W.O.S. reading of this, or whether or not he's decided to go down the rabbit hole of deciding that taxation that has a foreign component the president uses in order to engage in negotiations makes this a core Article 2 question. I think the other justice that I'm particularly interested in seeing is Justice Kagan. In West Virginia versus EPA, Justice Kagan said the major questions canon was a trick, that it was a get out of text free card, and a mechanic by which textualists can impose their own policy preferences on statutes that are otherwise clear. I'm curious if she's going to take a different approach at the argument and in any separate opinion, because I'm wondering if she might say, well, look, I dissented and I didn't agree with the major questions canon back then. I didn't think those were major questions because they were in the mere billions of dollars, but because this is a trillion dollar question and I lost those other cases, if anything is a major question, this is a major question. Or if she's simply going to say, no, the major questions canon isn't implicated at all because the plain meaning of the word regulate is not taxation. And so you can't tax imports through a statute that says regulate ... 16 words importation. I'm also curious, of course, to see what Justice Barrett says. Justice Barrett in Biden versus Nebraska, I think, put together the best articulation of what the major questions canon is. You'll note that I use the word canon and not doctrine. I think of it as a statutory interpretation canon, as opposed to a judge-made doctrine, and which is also how I got that idea from Justice Barrett. I am not, that's her reading of it too. It's just simply reading text in context. And in Biden versus Nebraska, she has, I think, the best analogy, which is, imagine some parents leave their kid with a babysitter. They leave $50 on the nightstand and they give the babysitter the instruction to let the kids have fun. And the babysitter takes the $50, steals a credit card, packs up the kids for a week, takes them to Six Flags. Kids have fun. Is that a faithful execution of let the kids have fun? Of course it's not. And I think I'm looking forward to seeing whether or not Justice Barrett is going to build out the major questions canon some more, hopefully she gets to write the opinion or in a separate concurrence, because I think it is pretty obvious that the president has been the ambitious babysitter on this one.
Peter, we've talked a little bit about the non-delegation doctrine sort of collaterally. Is that an issue that you think is going to play significantly in this at all? Is that a valid sort of alternative approach for any of the justices to take on this if they didn't want to buy into the statutory interpretation argument? What are your thoughts on that?
I think generally, I mean, just to step back at a higher level, I think for just a second, I think there's a lot of pretty serious cognitive dissonance going on here where you have your three more liberal justices who I think are going to be appalled by this power grab. But they have been obviously the ones who resisted on the major questions doctrine and also on non-delegation. I mean, so you've got, now is it a question of any port in a storm? I think it's probably easier for the three of them to say, as Zach just alluded to, let's just look at the statute. Statute doesn't have the words necessary to get you to where you need to be. The ones who've been the strongest on non-delegation are the ones who are, on Thomas and Alito are, probably the least likely to say, we're going to turn on the president on this one. And so, and then you have the ones in the middle who say, or what is more of the middle, I guess, today, that say, well, what we said this before, did we really mean it? And I think when you put those two together, I think there's some real, as I say, major questions doctrine along with non-delegation gives a path to say we're not going to do that. So if you're going to be faithful to it and it applies to both sides, then I think that makes it a lot harder, and that gets you to well over your 5 votes. But the ones who really like major questions doctrine, are they thrilled about doing it in this circumstance? Maybe not. Non-delegation, same thing. And so I'd be interested to. It's sort of like watching to see, is there someone who's going to make a run for it on one of these theories, and you go, oh, okay, they're all in on that approach. And we don't know, and we won't know until we see the argument, who's going to go where, because it's entirely possible that you could get all of them going for different reasons. You can't do that. Or you could, I think it'd probably just be a majority. I don't think it'd be unanimous going the other way, where you could say, yeah, well, we're going to twist and turn, and the words can mean this. The great line from Alice in Wonderland where, it says, this word means exactly what I want it to mean. And you know what? If you have 5 votes, that's what it means.
Zach, any thoughts on justices to watch on the non-delegation issue?
I think Peter's right that I would be interested in seeing whether or not you can get a situation sort of like in the second gun case, McDonald versus City of Chicago, where you get a situation where maybe there's a number of justices who say it's basic statutory interpretation, then you get an opinion by Thomas or on the other side saying it's no, this is the non-delegation doctrine, or Justice Gorsuch saying this is the non-delegation doctrine. I don't, and with all due respect to Peter's brief, which is, I agree, if IEPA does apply, it can be read so as to give the president a tariff power because there's no ceiling, because there's no floor, there's no intelligible principle. I don't think this is going to end up being a non-delegation case at the end of the day. I think this is going to be a statutory interpretation that bleeds into a major questions case. And part of that is because the non-delegation doctrine comes from a tariff case, J.W. Hampton Company versus United States from 1926, which instantiates the intelligible principle case, was about a challenge to delegated tariff powers to the president. You can distinguish that. WLF in our brief, we note the Tariff Act of 1922 gave instructions and limits to the president on what he could do. It was limited to trying to rectify the balance of trade. Also, there's a little bit of textualist weight to the statute being called the Tariff Act as opposed to, the International Emergency Economic Powers Act. But you still have to do that work. And I think it may just be much more straightforward to say, for whatever reason, whether it's because it's a major question or just the plain use of the English language, the word regulate just doesn't mean taxation.
If I could just add one more thing. Most people on the call who are following us probably didn't have to read all of the briefs. And the important thing to keep in mind, neither does the court. They don't have to read any of our briefs. But that a lot more people talked about non-delegation than major questions, which I found interesting. That people decided to draw the line there, even though, as Zach just said, there are those non-delegation cases, the big ones from the earlier days, came out of the tariff world. The only other thing I just wanted to add was that I think it's also worth watching to see, whether, Robertson Barrett on the concept of, are we worried about the optics of we have our doctrines that only apply to one side or the other, and the notion of, are we really just partisan hacks? And it's maybe some folks care about that and some don't, but I think they do, and so I think that they will want to tread carefully. I'm taking more of my allotted time. I'm sorry.
That's okay. Marc, go ahead.
Yeah. What's interesting about this case from an economics perspective is just there's no economics in this case. And you almost wish that somehow there would be a sidebar where everyone just huddles to discuss that tariffs can't do any of the things that are being alleged here. And a basic understanding of macroeconomics begs attention to the fact that even if you do have a statute that allows you to use a tariff to deal with a persistent goods trade deficit, the tariff will not accomplish the goal. So, in part, one of the most frustrating things about our brief, for example, was just in sticking to that one line while not saying that while it is the right statute, it's still the wrong answer. And you can feel the frustration in some of the briefs, which I agree with Peter. Maybe they will be read, maybe they won't. But the gravity of the moment is best expressed through these briefs, which are pointing out that this is a moment of economic illiteracy. And that shouldn't be lost on anyone. That in our discussions of major questions, non-delegation, IEPA, regulate, there's a missing component to this, which is it is remarkable that the dissent at the Court of Appeals gave credit for the bargaining chip theory with respect to these napkin trade deals, but never once asked the broader question about any of the other economic realities, including any of the macroeconomics surrounding what happens with a persistent goods deficit. And the final irony I'll mention is it didn't work for Nixon. You know, we have everyone citing Nixon. It did not work for Nixon. And even the Smithsonian Agreement did not bring stability in our time. It was only a few years before everyone was floating their currency. Somehow we have replaced Smoot-Hawley with Trump, but continue to stay as economically ignorant as Smoot-Hawley, and we're not even allowed to utter this in our briefs. That is a shame.
I suppose I
get
should
that
just
off my
note
chest. I'm sorry.
But Mark, we're lawyers. We're really afraid of math. Math is bad, but if we can make this about words, way better. We understand words.
Well, the words that we tried to offer follow a really nice graphic in which we depict over GDP the movement of balance of payments against the goods deficit, and my God, do those lines work in tandem. So again, empirically speaking, the data are screaming for attention. When Congress said balance of payments, it meant trade deficit. And if the president wants to pursue a remedy for a trade deficit, which by the way won't work, the answer is 122. And if IEPA is allowed to blanket bomb 122, then that strikes me as a big legal no-no, which, as Peter says, you got to decide. Do you ignore for one party or do you play consistent for both?
Zach, if a majority of the justices do end up ruling for learning solutions at V.O.S., what do you think is the most likely legal theory to garner 5 votes?
I think it's going to be major questions. I think that's the sort of lowest common denominator. I think you can you can get your Chief Justice Roberts, your Justice Barrett, who I agree with Peter. They are concerned about the legitimacy of the court and very wary about looking as if they're playing one side or the other. I think you can get a concurrence from Kagan and Sotomayor and Jackson, which either accepts the major questions canon cases or says we think this is basic statutory interpretation. But I think that's what's going to get the most votes. The problem, and I think Peter's right about this as well. I can see a universe where this is a 6-3 case where the president wins. That's a small likelihood, but I can. But I can also see a case where this is a 9-0 decision. And that's how much is in flux here. And you know, a lot of this may just be that I've drunk my own Kool-Aid on this because I believe in WLF's legal theory, but I just do think the president has put so much ballast in this word regulate, and it just simply can't bear it. Mark's absolutely right about the economic realities as well. I'm not going to do my Nixon impression, but I'm very tempted to. But that word just cannot bear all of the strain that the president has put on it. And I think that's ultimately going to get people to balk in the same way that, and you don't just have to go to the Roberts court on this. The FDA versus Brann and Williamson, the Clinton FDA said that the word drug allowed them to regulate tobacco products. And the court said, well, yeah, sure, the word drug might mean that colloquially. We know cigarettes are quote unquote drugs. But no, because the government has, when it created the Food, Drug, and Cosmetic Act, everybody used cigarettes. And there were many efforts by Congress to give the FDA the authority to regulate tobacco products, and those all failed. So no, we're not going to pretend that the word drug has this unusual meaning just because the Clinton FDA wanted it to. And I think that's really what you're going to see here. And just one other point on this, I think the fact that, again, no other president has ever picked this up is going to be instructive. No other president has used IEPA. And in fact, during his first term, the president in the 2019 State of the Union address asked for the authority to be able to impose tariff rates in order to improve America's balance of trade. He asked for passage of the Reciprocal Trade Act, of 2019. Congress declined to give him that authority. He now says, oh, they did that in 1977. Never mind. I just don't think that's going to wash.
What's the best outcome for the rule of law and the separation of powers in general, which isn't necessarily the same answer as what's the outcome going to be?
Yeah. So if I can just, my dream opinion, you get a 9-0 opinion. The Democrats don't join, the democratically appointed justices don't join on some chunks of it. But I'd like to see at least 5 votes saying that this is a major questions case, the word regulate cannot bear this. And then a lot of really good dicta about the non-delegation doctrine, that even if IEPA did go so far as to allow for some tariffs, it couldn't possibly bear the weight of the non-delegation doctrine to sort of put some meat and scaffolding on the intelligible principle doctrine. Maybe this is just me being disappointed in last term's outcome in FCC versus Consumers Research, but I think that would be the ideal rule of law opinion, saying that the president cannot do this, giving more weight on the major questions canon, making it very clear that it is a tool of statutory interpretation. It is not a clear statement rule. It is just about reading text and context. And then saying that as part of this, one of the reasons why we have to read regulate this way is because if regulate bore the weight that the president claims that it does, it would violate the non-delegation doctrine. That would be ideal. In a perfect world, that'd be a 9-0 opinion. I dream a lot, but I can't dream that much.
Just remind everybody real quick that if you do have questions, please ask them using the chat function. Mark, if you want to add something.
Yeah, I want to jump in where Zach ended. To quote the philosopher Steven Tyler, dream until your dreams come true. And I'm all with you on this one. I would love to see the 9-0 vote back the 3 of the 7 at the Court of Appeals who said no tariffs. None. That would be the most robust win. But my biggest curiosity is what Congress will make of the ruling, one way or the other. And let me paint for you my biggest fear. The justices uphold, and on January 31st or 30th, whichever the day is now that the 6 Republicans got the accelerated vote on, Congress votes to continue the national emergency. If that were to happen, Congress no longer has trade policy authority. It's over. So for whatever the court decides, the real interest lies in what Congress makes of it and what it does to claw back tariff authority or not. And I would wager that it hasn't failed to capture most people's attention that we are debating the 1930 Trade Act, the 1962 Trade Expansion Act, and the 1974 Trade Act. We have nothing modern that we are bandying about. And when you go back to Section 122's legislative history, what's clear is that they are referencing a time when all the GATT scholars agreed the global economy was the wild, wild west. Section 301 in that time frame meant something that really doesn't make a lot of sense more recently. We need an upgrade of U.S. trade legal architecture because it's all rooted in a time long gone by. And it shouldn't be lost on anyone that at a moment when the U.S. is in violation of virtually every international trade obligation it has, and when charming Betsy should be bandied about like my colleague Simon Lester insists it should in a more intelligible way, that we should be shocked and horrified by what we are witnessing. And hopefully that has some bearing on how the justices take this case next week.
Peter, any thoughts?
Yeah, I think that the court could best serve itself and the rule of law. Actually, if they just said, you know what, this is a simple statutory interpretation argument, and we just don't see that this statute had hidden in it for 50 years the power to impose tariffs. And if Congress wants to do it, we'll revisit that and see, if that's okay under the non-delegation doctrine in the major question. But we don't have to go any further than that today. The reason why I think that would serve them well is that then people would go, oh, all right, maybe they are willing to call it the way they see it, and they're going to apply it on both sides. And I also think, as Zach said, that might get you to 9 votes, or it could 8-1 or something, or even 7-2, something like that. A supermajority that's not, the usual 6 versus the usual 3. I think that's actually bad for the court. And I think obviously, from where I sit, one that upholds the finding that they don't have this authority here, would be the best result. And then you can deal with it tomorrow. I agree that there's a lot of storm clouds on the horizon, but having a split court, certainly having one that says that the president can do whatever he wants here, I think will further solidify the view that, the courts are totally in the tank for the president, which I think is probably not a good idea for the court, and certainly not a good idea for the country in this case. So I think I simple is the simple solution often is the best solution, and I think that actually, although I certainly constructed major questions in non-delegation, I think just saying you didn't do it. This statute was never intended to do this, and try again. And I think that would and everyone would live to fight another day.
Thanks, Peter. Zach, the biggest major question that the Game Manufacturers Association and Crutchfield and Princess Awesome will have is, if they do succeed here, can we get our money back? Can they?
I think the answer is yes. I think there's a case from 1998 about the harbor maintenance tax, United States versus United Shoe, I believe, where if there's an impermissible tax imposed upon you, you have a right to a refund. In fact, Yoshida was still at the Court of Customs and Patent Appeals, the predecessor for the Federal Circuit, in 1975, well after Nixon's short-term 1971 tariffs had expired. They still had standing. How'd they still have standing? Yoshida International was suing for its refund. So I think that's what you're going to see. The approximately $200 billion in tariffs that have been spent, you're going to see a lot of plaintiffs come in and say that they want their money back. And that is right and just. They should get their money back. These tariffs are unconstitutional and have been since the day the president put the Sharpie on the page.
Peter, Marc, any thoughts on President Trump attending the oral argument? Is that going to make a difference?
I don't see him doing it. I mean, he didn't like going to the court. Obviously, when he was a defendant, he didn't like being in court. So he has not good feelings about courts. And he also isn't able to dominate the room. He has to sit quietly, not allowed to send out tweets during the argument. I think he'll take a pass.
Marc, what do you think?
I would hope that Peter's right, because if he does attend, I think it could backfire in a very big way, and the drama would be that much greater, and the suspicions would weigh that much larger. And so hopefully he doesn't, but I don't even like the hint that he might.
Zach, final thought on that?
The president has a history of claiming he's going to go attend a co-equal branch and then not following through.
Very well. Seeing that we don't have any questions and we're almost right at 2, we'll bring our proceedings to a close. I want to thank Marc and Peter and Zach for sharing their thoughts today in such a concise and direct way. If you came in late, or somebody who might want to watch this, as I noted at the outset, this is going to be up on our YouTube page. So please enjoy watching it in full, or have someone else watch it. Also, when you log off, there'll be a very brief survey. If you could take 2 seconds or so to answer those questions, extremely helpful to us in sort of setting our expectations and figuring out if we're targeting these programs correctly. Again, thank you everyone for joining us, and enjoy the argument next Wednesday.